I'm Scott Lachlan. This is the Data Chronicles, and here are your data points. Today's episode continues our focus on the DOJ's proposed rules that would restrict and then sometimes prohibit cross-border data transfers. And this time we're going to discuss the rules with a specific focus on their impact on global compliance programs. Given the significance of these potential rules, we're publishing 3 initial installments. In the first installment, I provided an overview of the proposed rules and then discussed their significance with my partner, Ajay Kuntamakala. Later, we'll also do an episode that focuses on the unique manner in which the proposed rules will impact the health and life sciences companies. Because even though the rules apply to all organizations, they have unique impacts on some, in particular, the health and life sciences industry. But in this episode, I wanted to discuss maybe things that are a little bit more practical. The issues regarding how organizations can look to comply with these rules, and in particular, whether these are opportunities to leverage existing compliance strategies. Questions like, is the substance of these proposed rules already covered through other compliance resources? Does that look kind of like a sanctions regime, a privacy regime? All of those key questions. And frankly, who in an organization is likely to be the lead on these rules? And how do we get started with compliance, knowing that time will likely be short for such a significant effort ahead? I wanted to also understand the impact of the proposed rules on the financial sector in particular, because global money flows often involve global data transfers. So to discuss these issues and others, I've invited 2 of my partners to the podcast, Liz Boison and James Denvil. Liz is a financial regulatory lawyer who advises clients on digital assets and corporate compliance programs. James is a returning guest to the podcast. He's a privacy lawyer who works with clients to develop global data protection strategies, both of whom are deeply involved in assessing the impact of these proposed rules. Liz, James, welcome to the podcast.
Thank you.
Hello.
So, Liz, maybe I can start with you. I think as I'm looking at this rule, it's going to have large implications for really, many businesses operating in the United States, but especially those who are operating globally. And many of those organizations already have robust compliance programs that hit a variety of different legal obligations that they have that uniquely apply to them. How do you see these new proposed rules and compliance with those rules fitting into those existing compliance efforts?
Yeah, thanks, Scott. So DOJ has long had its process for analyzing compliance programs and making a determination for corporate liability based on those parameters. Those have included your standard sort of, 4 pillars of compliance: have an officer, do annual audits, have training, et cetera, with a lot more detail filled in. I think these rules take it a step further and are specifically promulgated under the sanctions law, IEEPA, which stands for the International Emergency Economics Powers Act, and really goes a great degree more granular into requiring a risk-based assessment of how likely a global business is to engage in the kinds of transactions that DOJ is concerned about here. And, so where a business is engaging in these kinds of transactions, known as restricted transactions involving bulk transfer of sensitive personal data, it is required to have a compliance policy. And these rules set out very specific needs for what that compliance policy must reflect, including transaction parties' identities, data end use and transfer methods, vendor identities, and they're certified annually by a responsible officer or employee, and they have to follow the security requirements established by CISA. So you had CISA also weighing in, which is new and different for a DOJ context.
Yeah, new and different. I think that's, clear when I look at these because in some ways you look at the compilation and this rule strikes me as a combination of a number of other things that we already have with a very different focus. You mentioned kind of the part like general compliance obligations and compliance programs, compliance officers that DOJ has long expected from organizations of this size. And so that's part of this. There is a sanctions component of this, looks very much in some ways like the sanctions laws that we have in this country. It looks kind of like a reverse CFIUS kind of angle to it. It has part privacy that's part of it. You mentioned CISA, it's part security, right? In other words, we've taken all of these components from different others, areas where we already have existing law, and now have perhaps refocused it on this specific area of cross-border data transfers designed to meet this new objective. Interested, is that how you see it, or do you see it kind of differently?
I do, and I think it gives prosecutors, both criminally in the National Security Division, who would be bringing cases under these rules, as well as on potentially the civil side, because there's civil liability that can attach. It gives them a clear framework for analysis of parties to these transactions, how it would view these transactions, and ensuring that there's adequate notice and uniformity for something that is so new and different.
Yeah. James, maybe I can ask you from your perspective on this. You're a data protection practitioner, have spent a long time working with organizations on global strategies to meet compliance obligations. These are obviously new, but you've done a lot of work out in the EU where, similar cross-border data transfer restrictions with a very different focus have long existed. Interested in your perspective about how a privacy compliance program can be leveraged to meet these obligations. And then maybe second, is this a privacy set of issues that privacy officers are going to now deal with, or perhaps the compliance officers that Liz was mentioning is going to have to lead? Interested in your perspective there.
Yeah, I think that's a really interesting issue, particularly picking up on what Liz was saying, where you've got DOJ enforcement and oversight looking at civil and criminal liability, which at first glance sounds like the privacy office is going to say, that is not my area. That is not the sandbox that I play in on a day-to-day basis. However, I think instead of looking at this framework sort of from the top down, looking at the regs and then designing the appropriate compliance program underneath it, just from scratch, looking at the existing compliance program and what you can leverage to address these new requirements, privacy does seem like a good fit because it's going to at least tag or be boots on the ground that are going to identify the types of transactions that this framework is looking at. So we're mainly looking at transactions that involve certain types of personal information and where that information is going to be accessed by third parties who are subject to the jurisdiction of certain countries, which is going to be a little bit of an odd wrinkle for some privacy programs. It tends to be focused on where is the data going out of and not always looking at the granular issues of which specific country are the resources or the data recipients located in. But if you're thinking about data brokerage, which I know you've discussed, that's broad, but we're going to be sharing information with a third party for their own use. Privacy teams, hopefully you're already going to be learning about those transactions. Employment agreements with the privacy terms, they're going to be flagging certain aspects of the transaction. So potentially just educating them about what additional questions they need to be asking will help identify the risks there. Vendor agreements, clearly privacy teams should be involved there anyway, so that you can train them to address the situations here. I think the one area where it may at times be complicated is the broad notion of what an investment agreement is, and essentially, any acquisition of ownership or assets in a company, and making sure that the privacy team is involved in some stock purchase agreement or whatever, where you're not even contemplating that this entity or individual is really going to access data, but has the ability to access certain data. So it's not a data transfer transaction inherently on its face. That may be the one wrinkle for a privacy program and for a compliance program more broadly to be able to flag those. But it does seem like a privacy function is going to be a good type of function to be able to fit in where whoever's going to own this particular compliance program, and maybe that's privacy, maybe it's trade, maybe it's other compliance functions. But it does seem like the privacy team is going to be one of the best suited because they're already asking these types of questions about transactions on a day-to-day basis.
Yeah, I think that's a good point. And then maybe interested in that, the questions that they're asking, typically they have not been focused in on data leaving the United States to another country and trying to understand what the rules are in the United States under that country's laws. Oftentimes I think they would ask, like, okay, if I transfer US data to somebody in another country, will that bring my US data to have to comply with the local laws in wherever it is I transfer, right? We get that question repeatedly. But this will be a new question that sounds like some of the questions we've had to ask in the EU and in Turkey and in Argentina, kind of a number of other places where there is restrictions around cross-border data transfers. What data is leaving? Where is it going? Kind of what is the amount of data? And then instead of perhaps asking questions about the local laws and how those laws are going to apply to protect the data that's being transferred, we now have to ask kind of a different set of questions about how it's being protected against access by the recipient country. I mean, does that sound right to you? Because I think it's a different set of questions. It's maybe another way of saying it's the same questions we've been asking, but now we have to ask it more broadly and with a different focus.
It's certainly, if your standard contract playbook is bifurcated, where the first question you're asking is, where does the data start? And there's one path that you go down if you're starting in the EU or in Turkey or Russia, let's say, and there's another path if you're going from the US. And that path on the US traditionally has been, as long as we're not dealing with certain, highly regulated data, particularly in the national security context, you're not going to be asking about the recipient country. But now that we're establishing high levels of regulation for fairly innocuous types of personal data, you're going to have to start asking that, where is the data question going, in the same way that we've been doing that for the EU. And again, the other wrinkle, though, is on those investment agreements. I think, for data brokerage transactions, for vendor agreements, for employment agreements, those seem like the type of things where it's not unnatural to shift your mindset to be asking, like, okay, where are we sending this data? But particularly on the investment agreements, where it's the ability to access, it's not just where are we sending data, because maybe there's no plans to send data whatsoever in the day-to-day. It is just an investment. But within it, there's the ability to access it, or the power to, some entity or jurisdiction who's going to be able to leverage its, control of a certain US-based entity in order to access data. That's going to be another wrinkle to figure out how to address that in a risk-based mindset. But for the bulk of the transactions that I think are at issue here, it's essentially taking a European mindset to data transfers and adding that on as a question that the privacy team or the other teams that are on the ground that are alerting privacy legal about what's happening. That's a fairly straightforward way to address this, at least based on the framework that we've seen right now.
And I just want to tag on to a point there that James made, because it's so excellent to think about how the scope of reviewing a deal as a compliance officer may increase, because you're not only interfacing with your privacy officer, if you have one, to find out exactly what is this and what could be the pitfalls or sort of the interpretations around the edges that DOJ could be giving here. And second, it requires a knowledge of your deal counterparty to ensure that they are not going to intercept and resell these data in a subsequent transaction. And I imagine, new reps and warranties will be coming in these kinds of contracts and will be expected not only for the contract parties, but for everyone else who's ancillary and working on the deal. They'll require representation from the parties that, this is not a deal that involves transfer of bulk sensitive data, and a certification maybe around that, so that the bank that is financing or closing the deal isn't exposed to liability. Even the law firm who is working on this deal can have some comfort about the contours of the deal and the eventual destination of the data.
Yeah, I mean, it's a really good point, Liz, because that area is one perhaps that there's a lot of confusion. I mean, I had a call just this week where somebody, said, I'm worried about these proposed rules because someone was talking about it with our board, and our board member came to me and said, well, if we are owned by a company based in China, based in Hong Kong, based in, wherever, we can no longer do business in the United States. Do we have to make plans to liquidate? And I'm like, no, I think we're kind of misinterpreting things in some ways. It's much more narrow than that. But the idea of understanding the corporate structure, and importantly, how we're thinking about data being able to move within that corporate structure, is really important and probably misunderstood.
Yeah, no, that's a great point. And in terms of, whether it's an intra-company deal, a deal that is central to what the business does, your core business is a data broker, so you're familiar with these kinds of transactions. But the ones that, around the margins that James was mentioning, where it may not be central or even the intent of the deal, but it's these kind of ancillary knock-on effects of sending data that may contain these sensitive personal details. And I'll just sort of bring it to the financial services realm for a moment. There is a carve out for data that is ordinarily incident to and part of the provision of financial services. So if you're sending a bulk file of ACH transfers or, a wire transfer, and a lot of those are happening between your institution and maybe even a covered person in a covered country, that, is exempt. However, DOJ has reserved the right to, really be looking at and scrutinizing what it means to be ordinarily incident to and part of the provision of financial services. This is a standard that we're familiar with working with. It's somewhat analogous to FinCEN regulations regarding money services business and what exemptions apply. So we've seen this before in the financial services world. That guidance can probably be instructive, but I would really want to know, if I were a compliance or privacy officer, exactly how that was going to be applied so that I don't get whipsawed in a regular, financial services transaction or batch data that I'm sending as part of my core business.
Yeah, that I just want to pause on for a moment, because it's almost, and maybe, Liz, you do a lot of work in the financial services sector and kind of have the expertise associated with understanding how all of this works. I would probably consider myself a layman with respect to the global transfer of financial data when we're talking about a transaction. If you are selling goods and services and from an e-commerce company, but it turns out that company is based in China. How is that? That when I'm processing a payment card here in the United States and transferring that data, where does it move globally? I'm not sure folks well understand that. I mean, and they could very well get very scared about how these rules, especially with the promise of civil and criminal penalties that would be associated with it, how much diligence needs to be undertaken for maybe not a simple swipe of a credit card, but more generally, as businesses are doing global deals, how much do they need to dig in?
Yeah, well, and certainly in financial services, one thing that companies are great at is record keeping, because they're required to do it ordinarily under their regulatory regime. What DOJ really seems to be looking at in these risk-based compliance requirements is retention of the information so that at any point they could come in, start asking questions. It sort of is, even absent an investigation, it's now become a repository where DOJ or others could come in and start asking for transaction records to make sure that they have a level of comfort. So for industries other than financial services where record keeping and compliance will be new, it will be a lot more of a ramp up, less so for financial services. But it also is important to know exactly what data are being transmitted. So when we're talking about incident to the financial transaction, okay, whom are you paying? How much? On what date? You probably don't need to be sending the location, excuse me, the location that the person's mobile phone was at when they did the e-commerce transaction. There would be, that is probably not falling in the bucket of incident to the financial transaction, even if it's collected by the U.S. financial services provider. That would be elements of data that do not go over. I think, if I were constructing compliance policy and, data fields to be transmitted to potentially covered persons.
Yeah, really interesting. And maybe James, I'd ask you a similar question, maybe with a broader scope, because one of the things that this law requires you to do is categorize data, classify data in ways that, maybe organizations don't do as an ordinary course, right? In other words, trying to indicate what would constitute financial data, health data, which are subject to different thresholds, and then how to think about the more complicated way that they're describing that the broader set of personal information, what types of categories associated with each other would then, would trigger the rules, whereas one set of categories that is not associated with the other may not trigger the rules. Just interested in your perspective about what this means for a data categorization strategy in general, or a classification strategy.
Yeah, I think that data classification, categorization, and also just the assessment of current compliance once we get there and what existing things you need to deal with is going to be challenging. Because if you look at the framework as it's written, it is not talk about it's unlawful to initiate a transaction that involves these prohibited or restricted transactions. It's to engage in these transactions, whether it was GDPR for European compliance when that came out in 2018, or dealing with California consumer laws, privacy laws when they came out in 2020. One of the big challenges for any company was saying, we already have thousands of vendors and thousands of vendor agreements. How on earth are we going to go through and update all of them to address the requirements under this law? Now we're going to have this transaction, and companies are going to have thousands of vendor agreements, maybe thousands of employment agreements with outsourcing to independent contractors or employment agencies, whatever firms they have for employment as opposed to the independent contractors, and investment agreements. And they're going to be engaging in those transactions next year when this framework may come into play. It's one thing for GDPR or CCPA if you're dealing with the privacy law acronyms, and you can look at a contract and maybe check the box and say, yes, it's got these provisions in it. Phew, we're good to go. Or we have to add these provisions to these contracts, and that's going to be a mountain of work that you can prioritize it and triage it. Here, it's not just the facial stuff on the contract. I mean, maybe you've got some good data categorization within the contract itself, specifying what data is going to be accessed and used. But that data categorization reflects European data protection laws or potentially US privacy laws, and it may not have been categorized in the way that reflects how DOJ is categorizing data for this framework. So it may take some knowledge to figure out, how do we map this? What is the actual data that's going forward? So we know that we're sharing some network identifiers and we know we're sharing names, but do we really know that we're sharing names and network identifiers of the same people? So it may take some further diligence on those agreements to figure out, it's like, oh, okay, no, we're sharing names of the contract negotiators. We're sharing IP addresses of the people who came to our website. Those are different people, so we can share both. And also, you're typically not going to see on a contract, okay, we're going to share location data, and we're going to share it of 10,000 people within a year. You're not going to get that information on the contract. So you're going to have to ask some questions. So it's not just contract review, it's contract review, figure out which is in play, then some diligence to find out the data, and then some diligence to find out who the co-party to the contract is, because that's often not going to show up on the contract itself. And if we're talking about, known or should have known that you were engaging in this, the contract may not say and may not reveal that the person who negotiated the contract had to travel to China 5 times in order to finalize the deal with the people who are really in play. So it may not be the contract itself that helps you. So that's where it's going to be a challenge for existing compliance functions as well, who are used to just reviewing contracts and relying on the internal processes that were making sure that the contracts contained what they should have, because those playbooks and those diligence functions were not designed to address this.
Yeah, really good point. So maybe as we close here, I would maybe ask you, just maybe each of you, one final question, because I think it's probably the one that many of our clients and many individuals who are eventually going to be responsible for carrying this through are asking themselves. There's 400 plus pages of this document that was released by the DOJ. We're obviously in the proposed rules now. Comment period is coming. We are expecting that a final rule is going to eventually come in place. We're also expecting that it's going to look probably very similar to the current proposed rule based on the approach that they took as part of the advanced notice of proposed rulemaking. But if I am the person who is, with inside, maybe Liz, for you, the person with inside of the corporate compliance program at a financial services company, or you, James, somebody who's sitting within the privacy team, and, my boss comes to me and throws this thing on my desk and says, what do I need to worry about? What should I be thinking about here? What are your thoughts on where you start? What is your practice point about what do I need to do to get myself ready for this thing? Liz, maybe
Yeah,
I'll ask you to
absolutely.
start.
I think the analysis starts with what kind of transactions does our company do, either in the ordinary course or as potentially ancillary to other kind of transactions that we engage in that might fall under this rule's ambit. And so, which of these countries or covered persons are we dealing with, or which of our transacting counterparts may be subsequently dealing with and passing on to these countries. I think the other thing, to be thinking about is a record keeping and reporting system. If it isn't already something that is part of my day-to-day bread and butter, I need to be starting those systems integrations and thinking about that now, and also need to be thinking about some of the data sources that I might need to build out that might not be available to me. So for instance, in looking at the rule, requiring annual reporting by restricted transactions involving cloud computing services, if they are 25% more directly or indirectly owned by a country of concern or a covered person. Right now, cloud computing services may not know and have not yet been required by the Commerce Department to identify if they are either hosting data or transacting with these kinds of countries. So on the first instance, it's really understanding where are the data ultimately going. And are they to these countries of concern? How can I go about identifying that in a way that is automated in case I need to be implementing record keeping or other transaction tracking before I engage in these? I think the other piece is reviewing the library of contracts and making sure that there are reps and warranties to address this, that you're requiring your counterparties to, say certain things, identifying the transactions, identifying, as James wisely noted, a potential cumulative effect of a series of small transactions that they can add up within a given year to be meeting volume thresholds that start to raise the risk calculus that a compliance officer should be looking at.
Yeah, really helpful points. Maybe James, same question to you from the perspective of a privacy officer.
Yeah, I think confirm that you either have or that it is accurate, a record of all of your data transactions. Make sure you have a reasonable, good inventory of the data you are processing as an organization already, and see that whether you can map that to the categories of data that are at issue here, just knowing what you have internally, regardless of whether it's going outside the organization, knowing where it is, knowing who's got control of it, then moving to, do we know which third parties we provide access to this data or disclose it to? Do we know where the contracts are? Do we know who the people are with the relationships with those third parties? So just good inventories underneath. And then adding on a new side bucket. And if it's in the privacy function, fine, or maybe another bucket is starting to take inventory of your investment agreements, at least knowing what you're going to have to start with. Know what data do we have? Who are we giving it to so we can deal with the data brokerage, vendor, and employment agreements? And then taking inventory of what are these investment agreements? What third parties have we allowed to have ownership of us? And then use that from the baseline to, you can then scrutinize those to figure out whether there are any implications from the framework. But without that, you're just going to be running around scrambling, trying to deal with things on a whack-a-mole basis, as opposed to having at least a good starting point of knowing where you need to go to look.
Yeah, really helpful practice points from each of you. So I really appreciate your time and your expertise and sharing that expertise with our audience. I'm sure there will be a lot more to come as we see these rules come into final effect, and then work with organizations to comply with them. But in the meantime, I really appreciate your joining the podcast. With that, I'm Scott Laughlin. This is the Data Chronicles, and those were your data points.